the whole intent of it is the orderly administration of your estate. Because if you've drawn out a will, you took the time to do that because you wanted those steps to happen. Hey everybody, welcome back to the Real Estate Show. I'm Tiffany Weber. I'm a real estate attorney at Thomas & Weber in Mooresville and Huntersville, North Carolina, and soon to be Denver, North Carolina. And I am joined today with Megan Anderson, or by Megan Anderson. That was a weird way to phrase it. Who, as you guys know, is another attorney in our office. So welcome, Megan.
Thank you.
I'm so excited that
back.
You're here. So I say I'm so excited that you're here. Like I don't get to see you every day, but I'm excited that you're back on the show. Because one, not only are you like a closing machine, but you're doing a ton of estate planning right now.
Yes.
And it's so relevant. I know this is the real estate show, but they go hand in hand and people don't realize that, I don't think. Just how much your estate plan or lack thereof can affect real estate transactions or like what you should be doing to prepare, you know?
Yeah.
So what I'm hoping that you will talk to us about today, is kind of like what are the basic elements of an estate plan, and kind of like a general idea of what those are. And then if we have time, maybe let's talk a little bit about trusts. Do you need one? Do you not need one? Do you want one? So yeah, if you just want to start by telling us like, what are the basic components of an estate plan?
Okay. So our basic estate plan, you have your last will and testament. Everybody knows it's your will. And that will go to the probate office to be probated. You also have your healthcare power of attorney and your living will. Some people think the living will and the will are the same thing. They are not. So living will, also called the advance directive, is kind of your last wishes, basically, of who gets to pull the plug, when they get to pull the plug, that sort of thing. Just kind of a more natural ending to your beautiful life.
Yeah.
And then lastly is a durable power of attorney, which is your financial power of attorney, somebody who gets to sign legal documents on your behalf.
Yeah. Yeah.
So.
That's like, you put it so succinctly. That's really impressive. And when you said the phrase pull the plug, I was kind of laughing to myself because, you know, I'm sure someone's going to comment and be like, pull the plug. That's not a nice way to say it. That's what our clients say.
Yes.
I was witnessing for you yesterday, and those were the exact words that the clients said.
Yes.
Is pull up the plug.
It's the easiest layman's terms.
Yeah.
You know,
like generally understood.
Yes. Machines, you pull the machine off of you.
Yeah.
So.
Yeah. That's, of course, in the document, they use more flowery language like desire for a natural death. But yeah, I mean, we take the approach of like, let's use the words our clients use.
Yes.
Because then they'll understand us easier.
It's more of a direct way. It's a delicate topic.
Yeah.
Either way. But it's the easiest way to understand it. So.
Yeah. And also it can sometimes like be used in a semi-humorous way, and people tend to calm down when they're,
we do try to make light of the subject. It is a, morbid, very deep, heavy topic, but if you don't have that conversation, you don't go there, then you're just going to be left to, the wind and where the state takes you. And that's really not where most people want to be at the very end. So
no. And, people might think that they don't have an estate plan because they haven't signed a document. Unfortunately, everybody has an estate plan. It's just a matter of, is it the one that your state has decided for you or one that you have chosen for yourself?
Yes.
So, if you don't know the state's laws and what the defaults are, then you might be surprised to find out that just because you've told your Uncle Bill, this is what I want done.
Yes. Well,
Uncle Bill might not have any say-so and have any legal ability or authority to do that, which takes me back to the last will and testament. Can you give us an idea of like what kinds of things can you include in a last will and testament? And when you said take it to the clerk's office and it's going to be probated, give us a little bit more insight into that process.
Okay. So on the will, we like to notate who your immediate family is. If you have a spouse, children, if you have specific grandchildren that you are really close with and that you're leaving specific bequests to,
$10 legal word,
giving them gifts at the very end. So we kind of spell out who's going to receive on your end specifically, personal property, which includes your vehicles, toys, household items.
My $25 necklace from Target.
Yes. Bank accounts, that sort of thing. And then also real property, which is real estate. And that kind of, we separate them only because there's different processes for each one. Mm-hmm. So, you have your people, your property. If you're giving specific gifts, we want to notate, how much is supposed to go to Susie Jane, grandchild versus how much is supposed to go to her mother. If also on that note, we also like to include people who are not receiving that are your children or grandchildren out of your will. That way nobody can say, hey, you forgot them and you actually meant to give them $25,000. We put it in there specifically. We give them, minimal amount of $1, $10.
And my love and affection.
And love and affection, because they could come back and say, hey, they forgot me.
Yeah.
And so we, spell the people in there, the property, specific items that are supposed to be distributed to those people, and then personal property, real property, residuary estate. If somebody doesn't want the 200-year-old China set that you have saved and, think it's worth a lot of money, and, your great-granddaughter doesn't really have any room for it, she doesn't want it, then that's going to get transferred over with your residuary estate, and then just kind of spells out how your executor is supposed to handle either giving it away or selling it, and then taking that monetary gift to be split the rest of the way of however you want to be distributed.
A residuary estate, I think of it kind of like the pot,
Yes.
Like you've got your line items that can be given out, and then whatever doesn't get given out goes into the pot, and then you just divide it equally from there.
Yeah.
Which is, I liked that you mentioned how you have to specifically call out who you're not giving stuff to, because think about it. This is probably what leads to a lot of estate disputes. You've got 4 grandchildren. You mention 3 of them and you don't mention the 4th. All 3 of them are getting the same thing. It could be viewed as if when you got your estate plan done, it was an oversight.
Right.
And why would the one grandchild not be treated equally to the other 3? Well, there might be all kinds of reasons. Maybe the one grandchild got all of that money during their life.
Right.
Or it could be that there's no relationship there, or there's all kinds of reasons, good or not. It's the client's decision to make.
Right.
And like we read wills all the time in the context of real estate, where like some people think they're getting the house and they end up says, I leave the sum of $1. And I've even seen one that was like, and not my love and affection. It's like, ouch.
Strong words.
Yeah. It's like they really wanted you to know you're not getting anything. Don't even try to contest it, which, people could still try, but like this, I mean it, and it's not an accident, and I'm specifically leaving you $1.
Yes. And just hopping off that one. So we do advise, like, you can put in there that, if you try to contest this will, then your portion is going to be X and you will not receive anything. That doesn't always hold truth when the probate court gets the documents. And I let everybody know if they want that specific language in their documents, like I could put it in there, but it doesn't always mean that that's going to, fold out, because anybody can contest a will. Doesn't mean that the judge is going to say, oh, you contested it, so your portion's, X for this reason. There could be all kinds of reasons.
The judges have broad powers of equity, just like in any lawsuit. They can kind of fashion the remedies as they see fit to make the parties whole. Right. So sometimes that might mean an outcome that you didn't intend.
Right.
Yeah.
So it's just not always a guarantee. We like to say, hey, in your will, it's going to be solidified, but it's 99.9% chance, but there's always that 1% that might go the opposite way.
If they go to court, we don't. So, nobody knows what's going to happen in court.
It's up to
unfortunately,
up to somebody else.
Yeah. Now, probate process. Everybody thinks that's a dirty word, and it can be a very difficult process. I'm not minimizing that at all, especially when there's been no estate plan done, and maybe there's property that's passed through generation after generation after generation. So it can be extremely difficult, but it doesn't have to be. So can you talk just not like super in detail about the probate process, but what happens with your will after you pass away?
Okay. So, and I'm going to elaborate a little bit more. So we'll get to the trust in a little bit, but people think that, oh, let's do a trust so I don't have to go to probate. That's not always the case. We still do a will just in case you forget something that's not already in the trust that then has to go through the probate process. Anything that requires a transfer of title, somebody has to sign off, transferring any, funds, signing off, making sure everything's accounted for if you have large debts. So we do a will. So just in case it has to be probated, the person, your executrix, anybody who's in charge of your estate, administrating, divvying out the funds or turning over the accounts or turning over titles, they are the ones who are going to probate your will. That means just taking some forms down to the probate office, county clerk's office, letting them know that you are no longer in charge of anything and you are gone. You'll have to also take, your death certificate, some other things that they require. Just, finalizing you have passed and now your property is going to your heirs and descendants. So the probate process is just the clerk reviewing all of the documentation, your will, death certificate, all that, posting informative newspaper clippings or something in like local newspapers, if that's still a thing. It can be done online. But you just have to give notice to any other creditors if you have a mortgage or any credit cards, outstanding medical bills. Basically, you're raising your hand saying, hey, if you have any claims against this person and or if you owe any money to this person, please come forward so we can get it settled. And then the clerk at the very end, they give you a final accounting, say this has been checked off, this has been taken care of, everything's been dispersed to the heirs, and it's all kind of through the will and through all the documentation that the clerk requires you to kind of settle all of your affairs.
Yeah, there's it can be like, that's a lot. I mean, there's no two ways about it. That's a lot of steps to go through.
There's not really a short and sweet version.
No, unless you don't really own anything. Like there's some procedures for like a small estate, but that's really small. I mean, like no money, no property, no cars, no anything really. It's like under 25,000 or something like that.
I was gonna say, I think it's under 25,000, and it's usually everything. Your spouse will have that just like short and sweet. Your spouse gets pretty much everything, and there's really nothing extra.
Yeah. But those are not super common.
No,
because it's rare that you have, it's rare that you'll have that available to you to do. So most likely you're looking at like the full probate process, which is, I mean, the whole intent of it is the orderly administration of your estate. Because if you've drawn out a will, you took the time to do that because you wanted those steps to happen. And the probate process is how it's guaranteed that those steps happen.
Yes.
That gives checks and balances to the person that you have appointed as your administrator, that they're not going off and, like you said, you wanted your car to go to your sister and the administrator has given it to their kid. That the probate process prevents that. Because there has to be like the checks and balances and the record keeping, it's all required by law. But I mean, even if you don't have a will, to be able to do certain things, you have to go through probate. Like not everybody goes through probate, but there are very specific circumstances where you don't need to. And that's, again, the exception, not the rule. But now I'm really interested in you talking about, it's such a misconception that if you have a trust, you don't have to go through probate. And I'm not going to steal your thunder, but in my opinion, most people that tell me they want a trust are never going to do all of the administrative steps needed to make the trust effective for what their purpose is.
Yes.
So without going too deep into it, talk to me about a trust and how does it contrast with a will? Like, what are the big differences?
So with a trust, it's kind of, I think of it as like a bucket as well. So your will is also that bucket to like get everything to divvy out to your heirs. A trust is a similar product, but it's during your lifetime. And it's not under your individual name. So anything in the trust will have to be under the trust's name.
Mm-hmm.
So I always advise, and through the will, we kind of dump everything into the trust, which is already in existence.
Mm-hmm.
Usually it's already been funded in some way, shape, or form. That's a key.
If it's not funded, it's
Key,
not,
yeah.
it doesn't
Key
do anything.
For trust, you have to fund it. And that, means creating a bank account for the trust, because you never know if you're going to need to pay something out of the trust or put money into the trust. You're going to have a bank account for that.
If you see a trust with $10 taped to the very last page, that's them funding the trust.
It is funded, and we always do funding by $10. We do it by assignment of personal property, just kind of a lump sum. We assign, vehicles, boats, anything that is considered personal property can be funded into the trust. That way it's just there if needed, if the trustee needs to take care of those items. But the big difference with the trust is it's movable during your lifetime. And that's a revocable trust, a living revocable trust. There's irrevocable trusts, which we don't do a lot of just because they're not as flexible. So irrevocable means you are not in charge of it. You have to name a trustee who is not yourself to take care of all your financials. And a lot of people just don't have that option, that person that they trust.
And that person will be making the call.
Yes.
Right, for what they think is best for you and your best interest.
Right. So another day, another topic for irrevocable trust. But normally we just do revocable trusts, which are basically husband and wife create. They are the grantors or the creators of the trust. We spell out all the trustee responsibilities. You can deed your property into the trust, meaning that it's not in your individual name anymore. It is under the trustee's name of the trust. That is another thing that a lot of people forget to do. Like, hey, we have this trust and my property's in the trust. But no, it's not. We didn't actually deed it. We didn't record a deed with the county into the trust. So that's something that you
it's not magic
have to do. Yes.
It's not the pen to paper signing the trust means now the trust owns all my stuff.
Right.
I mean, you still have to take steps.
There are steps, and there's lots of steps to get it completed, at least up to par. That will be sufficient for the non-probate aspect of a trust that people really want to get to. And so, deeding your property into the trust, naming the trustee as, owner. You also list like bank accounts, trust as, the owner of those bank accounts. Life insurance policies, retirement accounts, 401ks, IRAs. I always say, put your spouse as the primary beneficiary, but then name the trust as that secondary beneficiary. That way, those don't have to go through the probate process. If your spouse predeceases you, you forget to update your, retirement plans.
You've got a backup.
And then now they're going through probate because they don't have a designated person to receive them. And so I always say, if you have a living trust, just put it as a secondary beneficiary. That way it's there for you don't have to keep updating for beneficiaries if something happens.
Yeah. That's another thing about trusts is, the maintenance.
Yes.
I remember I was giving a presentation to a group once, and it was all about kind of like the differences in a will and a trust. And I think of a will like your crock pot, set it and forget it. And a trust is more like French cuisine or something that requires you actually have to be paying really close attention to it.
Yes.
Because you say you took the initial step, you deeded property into your trust, but then you sell that property someday and you buy a new property, but you don't buy it in the name of your trust. Oh, well, guess what? You've just lost the benefit of having your real estate in the trust. So if the trust doesn't own what you own, you don't avoid probate. But that brings us back to you mentioning you don't only have a trust, you also have a pour-over will.
Yes.
And talk a little bit more about, why do we call it a pour-over will and what does it do?
So the pour-over will, basically, your spouse always comes first. We don't want to throw everything into a trust. That should go to your spouse. That way they have the immediate access. But your residuary estate, like we talked about, personal property, real property, everything that is still in the estate that nobody has claimed or it's not specifically going to somebody, it's going to pour over into your trust. So then everything gets kind of lumped into the trust. And then for privacy purposes, people, they want something more. They don't want everybody to know all of their property,
Yeah.
Specific items, which is, listed out in a will. So we just lump it as a residuary estate falling into the trust. And then that way your trustee will then go by your trust agreement, the plan through that aspect, which is not having to be through probate and won't be public record.
Yeah.
And that privacy kind of makes them feel better.
Yeah.
In that regard. That way nobody knows like how many things are in your trust and how many cars you have or how many boats you have. And not everybody can say, oh, well, they have this much. This is their worth. And this is, knowing all your information that you don't want people in your business.
Preserves that element of like,
yes.
So even if you don't have a ton of assets, but you're extremely private, then maybe it's a good idea for you.
Yes.
So really it kind of what it boils down to is like will, probate assets, trust, non-probate assets. So even if you've got some stuff in a trust, but not everything, whatever is in that pour-over will, there is still, albeit easier, probate process to get everything into your trust. Yes. But what happens to it after that is private, stays with the trust. And so I'm hoping that people watching this, like knowing the questions that we get asked in the office and how complicated it can be, I feel like you've distilled it down into like a very easy to understand, like this is what you need to know.
Yes.
With the caveat that we're North Carolina attorney. Well, you're South Carolina licensed too, but we're in North Carolina. We're talking about North Carolina stuff, but there's a lot of states where it does work very similarly. So the general knowledge is kind of applicable. What did we not talk about with the states that like you wish people knew? I didn't give you a heads up on this question, so I'm sorry.
No. I was just going to go back to, the times that I recommend to get a trust, if, you're really on the fence. So if you have young children, so a trust can also give your children chunks instead of just, at 18 years old, they're this, and you have, $3.5 million going to your children. You can reserve how they receive that money.
Yeah. Maybe not all $3.5 million at once.
Right. So at 21 years old, if I were to receive $3.5 million, I probably wouldn't have a dime of it left.
Yeah. So, I wouldn't have a law degree. That's for sure.
So that's also, so if you have young children, kind of lets you kind of restrict their access to all of your estate.
But gives you the flexibility for the trustee to provide for them as needed. So it's not like completely restricted access. They can't go into it, but the trustee has the ability to like, you got to pay for school? Cool. They need a new car? Okay. Not a Maserati.
Healthcare. Right. The trustee always has discretion, and you create that discretion of your trustee, like how, supporting your children throughout school, if they reach, get their college degree, they get this chunk at this time. You can give them monthly stipends, keeping them afloat, but also making them, have their own drive to get where they need to be.
You can get really creative with those too.
Yeah.
And it's possible maybe not all of the super creative ones would be upheld, but I'm sure people have seen like the TV shows where it's like, if I stay married for 1 year, then I get X amount of, there's a new book. So I know you read too.
Yes.
Christina Lauren's new book, I think it's called The Paradise Problem, has a plot like this about having to do with the trust of a very wealthy family, which I think you would like it.
I'll pick that one up. Yeah. So you can, plan out how like disbursements are supposed to be made to your beneficiary, to your children, limiting their full access to the estate, but also taking care of them at the same time. Also, if you have multiple properties, either throughout different counties, just in North Carolina, or different states, you deed them into your trust. That way they are all in one area. That way you don't have to open different probates for each of those properties. They're already under the trust.
Yeah.
Yep. So you don't have to keep opening different, accounts, files with different probate offices. So it kind of limits your need for reopening probates in all of those different areas, locations.
Which is an administrative nightmare.
Yes.
Yeah.
So multiple properties, young children, and anything over like 5 million, I think, is our threshold. Like if you have your net worth over $5 million, you really should have a trust to like at least minimize estate tax.
Yeah, this is when your estate planning attorney and your CPA are going to be good buddies during that process if you have a significant estate.
Yes. We're not going to talk about estate tax.
Yeah. We are gladly not tax attorneys.
Yes. Different time, different day.
Yeah. Well, awesome, Megan. Thank you so much. Like, I think that was super informative, and I appreciate you taking the time to kind of go through like not only the basics of an estate plan, but what does probate really mean? And then also like trust. Do you need one? Are you going to do what it takes? It's like when your kid wants a pet.
Are you committed?
Are you going to feed this pet? Are you going to take your dog for walks? Or, that's kind of how it is with a trust. Are you going to use it properly?
Yes.
Okay. Well, awesome. Thank you so much. Thanks again, guys, for watching the Real Estate Show. We will catch you in the next episode.